All right. Please, can you all hear me?
Yes, Your Honor.
Uh, Good morning, Miss Daya.
Good morning.
I think you may be good to go. Deputy, can you hear me?
Sorry, Your Honor, say it again.
I was asking, can you confirm whether or not we need an interpreter this morning?
Spanish? Espanol?
I don't think we did.
I think we're good, Your Honor.
All right, Miss Daya, you are good to go. Thank you.
Yes, sir.
All right.
Thank you. Have a good day.
You too, ma'am. All right, good morning, ladies and gentlemen. It is 11 o'clock a.m. here on December 28th of 2024. My name is Judge Marcus Thorpe, and this is the first appearance here in the Clayton County Magistrate Court. I am here, ladies and gentlemen, but there are several things I'm going to speak to you all about that are very important. So during the course of this morning's hearings, if you're having trouble hearing me, please let me know during the course of my introduction as well as during the course of today's hearing. First and most importantly, ladies and gentlemen, please understand, I am not here to take a plea. I am not here to have any legal discussion about the specific facts of your case. If you believe you have a defense, that's for you to speak about with your lawyer, not here. This is being recorded live, not to mention the people who are on here, as well as those who are present in the jail with you. You make all of us witnesses, ladies and gentlemen, if you decide to tell me something that is important, and understand that that can be used against you as your case moves forward. As we move through this hearing this morning, I need you to understand that the purpose of today's hearing is to inform you of what you've been charged with, to advise you of certain rights, to set bond on those offenses for which the court is authorized to set bond, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. Each of you has the right to remain silent. Again, please do not tell me any specifics about your case or any legal defenses that you may have. As I said earlier, we are streaming live. Now, in addition to the right to remain silent, you have the right to the presumption of innocence, the right to an indictment by a grand jury for felonies or by accusation for misdemeanors. You have the right to a speedy and public trial by jury, the right to compel the attendance of witnesses to testify on your behalf, to see, hear, and question witnesses who are called to testify against you. You have the right to testify on your own behalf or offer evidence in your own defense. You have the right to an attorney to represent you. And if you cannot afford one, I will determine whether or not you qualify for me to appoint one to you free of charge. Now, in addition to talking to each of you about what you've been charged with, I'm also going to talk to you about bond. Bond is an amount that you can pay to the sheriff or to a bonding company who would then hold that money and would allow you to be out until your case is closed. There are three ways to make bond, ladies and gentlemen. You can make bond through a cash bond, through a property or commercial bond. You can make bond through a cash, property, or commercial. So the example that I like to use, I'm going to tell you what you're charged with this morning, and then I'll tell you what your bond is. So if I tell you you're charged with battery family violence and your bond is $6,000 and you wanted to use a cash bond to get out, you would have to pay $6,000 plus any associated sheriff's fees to the sheriff. The sheriff would hold that money until your case is closed, at which time after it's closed, that money will be returned to you minus the fees. If you were to say, I don't have that amount in full, then you would use a commercial bond or a bonding company. And they would only ask for about 15% of that $6,000, which means you would be responsible for roughly $750. The difference is you don't get that money back. Lastly, there is a property bond. So again, if I tell you your bond is $6,000, you or someone you know would have to have at least 3 times that amount of bond in equity in their home. And then you would bring a copy of the deed up to the sheriff's office, who would hold that deed until your case is closed. Now, in addition to advising you what you've been charged with, as well as what your bond is, ladies and gentlemen, there are some of you all who will have special conditions on your bond. That means you are to have no contact with certain people or not to go certain places. If I tell you, ladies and gentlemen, that again, as an example, you're charged with battery family violence, and that you have no contact with the person that you're alleged to have assaulted, that means don't have contact with them. Don't email them, don't write them, don't text them, don't call them, don't DM them, don't even do them something as nice as write a song. If I tell you not to go back to a certain place, don't go. even if that was a place that you were living before this happened, please understand you are not allowed to go back to that address unless your bond is modified or your case is closed. Because if you do, ladies and gentlemen, you will be subject to a new felony charges to include aggravated stalking or influencing a witness, and up to 20 years in prison and $20,000 in fines and fees. The only way you could go back to that address and your bond not be modified or your case not be closed is if you make bond and you get the sheriff to go with you within 10 days of your release to get items that belong to you. Now, after today's hearing, ladies and gentlemen, there's several of you that may want to bond out today. Please understand you cannot use the alleged victim to bond you out. It does take a few hours for those of you all who do bond out or are released today, so please keep that in mind. There are also some of you all I will not be allowed to give bond to today based on the fact that you are either on probation or because of what you have been charged with. Now, lastly, ladies and gentlemen, we're going to talk about preliminary hearings. Preliminary hearings are hearings, not your trial, where you, the defendant, the attorney, your attorney, the judge, as well as the officer who arrested you are present, and they are present there to go over the evidence in your case. They're not there to eventually determine your guilt or innocence, but just to determine if there is enough evidence against you to go forward to the prosecutor. So those of you all who are charged with felonies, you automatically get a preliminary hearing unless you make bond. But those of you all who are charged with misdemeanors, you have a right to that preliminary hearing, but you don't have to. You can tell me, Judge, this morning, I don't want that preliminary hearing and that you would much rather me skip it and then send your case directly on up to the prosecutor. Now, there's some benefit, obviously, doing it that way because it does make it move a little faster by me skipping the preliminary hearing and then going directly to the prosecutor. But again, ladies and gentlemen, for those of you all charged with misdemeanors, up to you, you have that choice, and I will ask you what you would like to do. With that, ladies and gentlemen, if I could have everyone please go ahead and raise your right hand. All right, ladies and gentlemen, do you swear or affirm that the information that you've provided on your court-appointed counsel sheet this morning, as well as what you will provide here at the hearing, is the truth and nothing but the truth, so help you God? And if that is the case, I need you all to say, I do. All right, if we can go ahead and get started. And I think you're on mute, Deputy.
Appreciate it, Your Honor.
Brown,
Last name.
All right, so moving to Jots first, I have Brown, Penn, and Robert on Jots. Brown, Penn, and Robert.
Yes, Robert, some second.
All right, good morning. Are you Miss Brown? All right, so Miss Brown here, you are charged with 1 count of battery family violence, ma'am. That is a misdemeanor. And so that means, Ms. Brown, that you have a right to a preliminary hearing that I mentioned earlier, or you can waive that right to that preliminary hearing. Would you like to have that hearing, ma'am, or waive it?
Waive it.
All right, so I am going to show here this morning that you are asking me to waive your preliminary hearing, ma'am, and then based on that, the deputies will have a piece of paper that they're going to need for you to sign once we're done. Now, as to your bond, ma'am, on this battery, your bond amount is $3,500. You do have special conditions, and they are to stay away from the alleged victim, Alea Brown, as well as the address of 15 Pace Ridge Drive. Do you understand that, ma'am?
Yes.
Now, because I'm asking you to stay away from there, if that was an address that you were living at some point, please understand that if you make bond, then you will have to get with the sheriff's office within 10 days of your release to escort you there in order to get any items that may belong to you, okay?
No problem.
Now, ma'am, I see here that you're working and you have 2 children. Is that right?
Yes, sir.
Are you getting any additional support, or do you take care of those children alone?
I take care of my kids myself.
All right. So based on that, ma'am, I am going to go ahead and appoint you a court-appointed lawyer here this morning. And so you will have a lawyer free of charge. And with that, ma'am, that's all I have for you this morning. Unless you have questions for me, that's all I have. Good luck to you, ma'am.
No problem. Thank you.
Y'all, Penn,
Yes, sir.
Penn is next on Josh. You want to do Penn or Roberts?
I have Penn and then Robert. Penn, Roberts, and then Robinson.
Yes,
Penn,
sir.
Roberts, Robinson.
Hello.
Good morning. Are you Miss Penn?
Yes, sir.
Ms. Penn, you are charged with 1 count of battery, 1 count of criminal trespass, ma'am. Those are both misdemeanors, which means you have a right to a preliminary hearing, or you can waive that right to the hearing. Would you like to have that hearing or waive it, ma'am?
I'll waive it.
All right, ma'am, I am showing here that you'd like me to waive your hearing. And so as I told the person before you, that does mean that the sheriff's office will have some paperwork for you to sign. As to your bond amount, ma'am, the battery is a bond of $4,000, the trespass $3,000 for a total of $7,000. You do have special conditions, ma'am, and they are to stay away from a Miss Brianna Smith. Okay? Do you understand that, ma'am?
Yes, sir.
Now, based on the information you provided to me here this morning, Ms. Penn, I've gone ahead and appointed you a court-appointed lawyer, so you will have a lawyer free of charge to assist you on your case. Good luck to you, ma'am.
All right, thank you.
Thank you.
Have a
lady,
good
step up.
day.
All right. After Ms. Roberts should be Robinson, Thompson, and Tobin. All right. Are you Ms. Roberts? Are you Ms. Roberts?
Yes, sir.
All right, Ms. Roberts, you are charged with 1 count of battery, family violence, and 1 count of criminal trespass, family violence. Those are both misdemeanors, ma'am, which means you have a right to that preliminary hearing, or you can waive it. Would you like to have it or waive it, ma'am?
Yeah, I'm saying it's not really working. I'm good.
I'm sorry?
Waive it.
All right.
Okay. I am going to show, ma'am, that you are asking me to waive it. So again, the deputies will have some paperwork for you to sign showing that that's what you requested.
Yes, sir.
As to your bond amount, ma'am, your bond on the battery is $3,500, on the trespass $2,500, for a total of $6,000.
Okay.
You have special conditions, and they are to stay away from Mr. Earl LaFrance and the address of 319 Gardenwood Drive. And so, as I said earlier, if that is somewhere that you were living, ma'am, prior to this offense happening, please understand, as I've told everyone, you're not allowed to go back there unless and until your case is closed or you make bond and the sheriff's office goes with you. Do you understand that?
Yes, sir.
Bless you.
All right, ma'am, I have granted you an attorney free of charge here this morning. And so you will have an attorney to assist you. Good luck to you, Mr. Robert.
Thank you.
Thank you.
Did she waive, Your Honor? I didn't catch it.
Yes, she did.
Okay. Hey, can you sign her, waive?
Yeah,
Are you Miss Robinson?
Yes, sir.
Ms. Robinson, you are charged with 1 count of battery family violence, ma'am. That is a misdemeanor. And so you have a right to a preliminary hearing, ma'am, or you can waive that right. Which would you like to do? Have it or waive it?
Waive it.
All right, Ms. Robinson, I am going to show here that you're waiving your preliminary hearing. So that does mean that the deputies will have a document for you to sign.
Yes.
Based on the information you provided to me, ma'am, I am going to go ahead and appoint you a lawyer free of charge. Your bond amount on the battery is $3,500. You do have special conditions to stay away from Nicholas Barham and the address of 12230. Again, that's 12230 Edgewater Drive here in Clayton County, ma'am. Do you understand that?
Yes, sir.
Do you have any questions about anything, ma'am?
Yes, as I was leaving, he voluntarily decided to.
Ma'am.
I'm
Nope.
just asking.
No, ma'am. We will not get into the facts of your case, Ms. Robinson. As I told you that before, this is not the place for that. This is also being recorded. So anything you say can and will be used against you in the court of law. Do you understand that, Ms. Robinson?
Yes. So
Please do not say those things on this recording. Is there anything I can help you with beyond that, ma'am?
I just want to know if he leaves, can I go home? That's it.
I'm not allowed. That would be for you to speak with your attorney about, ma'am.
Okay,
I cannot give you legal advice, okay?
I was just asking. I didn't know.
That's okay. That's not a problem. I just don't want, I'm trying to protect you. I don't want you to say something that's gonna hurt you, okay?
Okay.
All right, that's all it's for, ma'am, but good luck to you.
All right, thank you.
Thank you. All right, it should be Thompson and Tobin. Should be the last of the females on job.
Thompson.
Thompson and then Tobin. Good morning. Are you Miss Thompson?
Yes.
All right, Miss Thompson, you were charged with 1 count of simple battery family violence, ma'am. You were charged with 1 count of cruelty to children in the 2nd degree as a misdemeanor. Should have been a felony, though. False imprisonment is charged as a misdemeanor, but that is a felony, ma'am. And you're also charged with 1 count of cruelty to children in the 3rd degree as a misdemeanor. Now, in reviewing this, ma'am, I have dismissed cruelty to children in the 2nd degree. I've also dismissed the cruelty to children in the third degree. And so you're only facing the false imprisonment and you are facing the simple battery family violence. The false imprisonment, ma'am, is a felony. The other matter is a misdemeanor. Do you understand that, ma'am? Okay. Now, because you are charged with a felony here, ma'am, that means that if you do not, Ms. Thompson, make your bond, you're going to have a preliminary hearing. You are required, you're entitled to it because you were charged with a felony. And so your next court date, if you don't make the bond that I'm going to give you here this morning, is going to be January 27th at 8:30 a.m. via Zoom like we are here this morning. Again, that's January 27th. That's 8:30 a.m. and it's going to be via Zoom. Now, as to your bond, ma'am, your bond amount on the battery, simple battery, is $2,500. The bond amount on the false imprisonment is $5,000 for a total of $7,500. Do you understand that, ma'am?
You said 7,000. You was breaking
7,500 is going to be the total.
7,500.
Yes, ma'am.
Okay.
All right. And you do have special conditions, ma'am. And those are to stay away from, it's a Shuntavious Thompson, as well as stay away from the address of 2002 Battle Creek Village Drive. Again, that's 2002 Battle Creek Village Drive. Do you understand that, ma'am?
Yes.
All right. And as I said earlier, if that's somewhere that you were living previous to this incident happening, if at some point you make your bond, you just need to get with the sheriff's office and they will escort you there to get anything that belongs to you, okay?
Okay.
All right, any questions I can answer for you, ma'am?
No.
All right, good luck to you, ma'am.
Thank you.
Thank you. All right, to be Miss Tobin. Are you Miss Tobin?
Yes, sir.
All right, Miss Tobin, you are charged with one count of felony criminal damage to property in the second degree. Because that is a felony, ma'am, you will get a preliminary hearing if you do not make the bond by that hearing date. So your next court date, ma'am, is going to be January 27th at 8:30 a.m. via Zoom. Again, that's January 27th, 8:30 a.m. via Zoom. Your bond amount is $3,500 for the one count of criminal damage. I have also given you a lawyer free of charge based on the information that you provided here this morning. Do you understand that, ma'am?
Yes.
All right. So do you have any questions of me here this morning?
If I post bail, do I get this information for the court date?
So what'll happen if you, thank you, that's a good question. If you post bond, make sure that the last known address that you provided here to the sheriff's office is the best address for you, because once you post bond, they send your new court date to that last known address.
Okay, that's okay.
Okay. Any other questions, ma'am?
No, sir.
All right. Good luck to you, Ms. Tobin.
Thank you.
All right. I'm showing no women off, Jots, so we should be on to the men on. And
Now,
I
you got,
have,
1 second, y'all, you got one off.
I got one off.
One that's not on, one female that's not on jobs.
Oh,
Last
I'm
name.
sorry. What's your name, ma'am?
Rudolph.
Say it one more time. I can barely hear you. Got to speak up.
Rudolph.
Can you spell it for me?
RUDOLPH.
Oh, Rudolph. Okay. Give me 1 second. Excuse me, ma'am. I apologize for not catching that.
Hey, to Garcia. Garcia,
What about
the medical is still in.
first?
Yeah, so we get him back to medical.
All right, so Ms. Rudolph, I'm showing here that you are charged with a count of criminal trespass, ma'am. That is a misdemeanor. Now, because that is a misdemeanor, you have a right to the preliminary hearing I spoke of earlier, or you can waive that right. Would you like to have that hearing, ma'am, or waive it?
No, I need a hearing.
Okay. So I am going to go ahead based on the fact that you are requesting that hearing. You do not make the bond that I'm going to give you this morning, ma'am. Then you will have that preliminary hearing date that will be approximately 30 days from now. The bond hearing for misdemeanors is January 28th of 2025, and that's at 8:30 a.m. and that's via Zoom. Again, that's January 25th. That's at 8:30 a.m. and that's via Zoom. Do you understand that, Ms. Rudolph?
Yes, and you put in the hearing that the reason why I want to hear it because I'm gonna get out and do the same thing because I'm homeless in the city of Atlanta. They won't let me get no housing or anything like that. So why would you continue to do the same thing and you move from another state to do better in the
Ms.
state?
Ms. Rudolph,
Yes,
I'm gonna
sir.
have to ask you not to say that.
What about me though?
Ms. Rudolph, please listen to me. Your bond amount, ma'am, is $2,500, and ma'am, you are to stay away from the Atlanta airport, unless you are there for work or you are there for travel. Do you understand, Ms. Rudolph?
That's the problem.
All right, ma'am, good luck to you. Thank you. Thank you, Ms. Rudolph. All right, so then I have now Barber, Bernie, and Canada. Are you Mr. Barber?
Yes, sir.
All right, Mr. Barber, you are charged with 1 count of possession of marijuana with intent to distribute, 1 count of possession of marijuana over an ounce, possession of THC oil, drug-related objects, up 2 counts of obstruction. Because you are charged with felonies, sir, you will get a preliminary hearing if you do not make the bond that we're going to go over here shortly. Now, reviewing the information that you provided to me, sir, you do qualify for a court-appointed lawyer. So that means I am going to give you a lawyer free of charge for your case. Do you understand that?
Yes, sir.
So looking at the charges here, Mr. Barber, the possession of marijuana with the intent to distribute carries a $10,000 bond. Possession of marijuana over an ounce, $10,000 bond. Possession of THC oil, $3,500. Drug-related objects, $500. And then the 2 obstruction counts carry a bond of $2,500. Your total bond amount, sir, is $29,000. You do have special conditions, sir, and those are to stay away from 5780 Riverdale Road. Again, that's 5780 Riverdale Road. So that would be where this incident was alleged to have happened at the gas station. Do you understand that, sir?
Yes, sir.
All right, sir. That's all I have for you today, Mr. Barber. Unless you have any questions for me, good luck to you, sir.
Thank you.
Thank you.
Hey, right, Bob.
All right. Are you Mr. Bernie?
Yes.
Good morning. So, Mr. Bernie, you're charged with 1 count of window tint violation, 1 count of possession of marijuana over an ounce, 1 count of possession of marijuana with intent to distribute, and 1 count of possession of a firearm during the commission of a crime. I have dismissed the possession of marijuana with the intent to distribute, sir. So you'll no longer be facing that charge as of right now. Based on the information that you provided to me, sir, you do not qualify for a court-appointed attorney, and so you would have to attain your own if you would like one for your case. Do you understand that?
That's correct.
All right, so now as to your next court date, sir, if you don't make the bond I'm going to give you, your next court date is going to be your preliminary hearing, and that's going to be January 27th at 8:30 a.m. via Zoom. Again, that's January 27th at 8:30 a.m., and that's going to be via Zoom. Now, your bond amounts are the following. The window tint carries a bond of $500, possession of over an ounce, $6,000, possession of firearm during the commission of a crime, $10,000. Your total bond amount is $16,000. Do you understand that, sir?
Yes.
All right. Do you have any questions about anything from me, sir?
I appreciate it. Thank you.
All right. Good luck to you, sir.
Hey, right, too.
All right. Next up to be Canada Co. and Currents. Canada Co. and Currents. All right. Are you Mr. Canada?
Yes, sir.
All right. So, Mr. Canada, you've got 2 cases here we're going to go through. The first here, just so that you know exactly what we're talking about, is from the date of September 7th of 2024. You were charged, sir, with 2 counts of terroristic threat, 1 count of home invasion, 1 count of aggravated battery, 1 count of possession of a firearm during the commission of a crime, 1 count of criminal damage to property in the 2nd degree, and then 2 counts of cruelty to children in the 3rd is misdemeanors, criminal trespass as a misdemeanor, and ag assault as a felony. Because you are charged with felonies here, sir, you are going to get a preliminary hearing. Your next court date, I'm going to give you 2, but your preliminary hearing is going to be January 27th. That's going to be at 8:30 a.m., and that's going to be via Zoom. Again, that first hearing date is going to be January 27th, and that's going to be at 8:30 a.m., and that's going to be via Zoom. Now, I'm going to give you a second court date. That second court date, Mr. Canada, is going to be January 31st at 8:30 a.m., and that's also going to be via Zoom. Again, that second date is going to be January 31st, and that's going to be at 8:30 a.m., and that's going to be via Zoom. I am going to give you a court-appointed lawyer here, sir, free of charge. Now, as to your bond on this first case, the terroristic threats, which are misdemeanors, each carry a bond of $10,000 apiece. Home invasion, sir, you're on a no bond. Aggravated battery, no bond. Possession of a firearm during the commission of a crime, no bond. Criminal damage to property in the second, no bond. Cruelty to children in the third, which is a misdemeanor, 2 counts, $5,000 each. Criminal trespass, $5,000, and the aggravated assault, which is a felony, is a no bond, sir. You do have special conditions if you are later given a bond. Those are to stay away from Marviona Payne and from the address of 624 Red Fox Trail. Do you understand that, sir?
Right.
I'm sorry?
Yes, sir.
Okay. Now, as to that case, sir, do you have any questions of me on that one?
Sure.
All right. So now then, Mr. Canada, you have a second case here that you had allegations on as well. I'm going to give you the date on that one here just so you know which one we're talking about. Those allegations are from October 5th of this year, 2024. In that case, sir, you are charged with 1 count of cruelty to children. The first is a felony, 1 count of terroristic threat as a felony, 1 count of ag assault as a felony, burglary as a felony, and battery as a misdemeanor. Again, you got 2 court dates on that one, same 2 court dates. Preliminary hearing on the 27th of January. Your bond hearing is going to be on the 31st. Now, I've gone ahead and, of course, on that one again, giving you a lawyer free of charge to assist you on your case. Do you understand?
Yes.
All right. Now, as to your bond, give me 1 second here. I'm just typing in some stuff. Make sure this is clear.
Check.
Coming in on
You get checks? Okay. You can come back over here and work.
Okay. Now, as to your bond, sir,
Yeah.
the cruelty to children in the first degree is a felony. You're on a no bond. Terroristic threat, no bond. Ag assault, no bond. Burglary in the first, no bond. And then you have the battery, which is a misdemeanor, sir. Your bond amount there is going to be $5,000. And so again, as I said, you're going to have those court dates, the 27th of January for a preliminary hearing. The 31st of January will be the bond hearing where they can reconsider your bond at that time. All right, good luck to you, Mr. Kendall.
Thanks, Mr. Book. Hey, Mr. Anderson.
Give me 1 second.
Good job, Roger. What's up?
Yeah, they opening the door.
Use the radio.
I already did.
I hear you.
Yeah.
Sorry, one
All right, and are you Mr. Currents?
I'm Mr. Cole, C-O-E.
Oh, excuse me, I apologize. Yeah, Mr. Poe.
Yes, sir.
Yes, Mr. Poe, you are charged with 1 count of cruelty to children in the second degree as a felony and 1 count of reckless conduct as a misdemeanor, sir. Because you are charged with a felony, if you do not make the bond that I'm going to give you here today, sir, your next court date, your preliminary hearing is going to be on January 27th at 8:30 a.m. via Zoom. Do you understand that, sir?
Yes, sir.
Now, I am going to go ahead and give you a court-appointed lawyer, sir, so you will have a lawyer free of charge to assist you on your case. Now, as to your bond, bond on the cruelty is a bond amount of $10,000. On the reckless conduct, $2,500. So your total bond is $12,500. Do you understand that?
Yes, sir.
You do have a special condition, sir, and that is to stay away from the alleged victim, Miss Mia, Tamia, Cole, C-O-E. Do you understand that?
Yes, yes, sir.
All right, sir. Unless you have any questions for me, sir, that's all I have for you this morning. Good luck to you, sir.
All right, thank you.
Thank you. All right, and then after Mr. Currents, should be Dudley, Hammock, and Kelly. Dudley, Hammock, and Kelly.
Yes, sir.
All right, are you Mr. Currents?
Yes, sir.
All right, Mr. Currents, you are charged with 1 count of felony arson, 1 count of burglary, 1 count of financial transaction card theft, 1 count of robbery by force, 1 count of kidnapping, 1 count of battery as a misdemeanor, and 1 count of possession of drug-related objects as a misdemeanor. Now, because you are charged with a felony, sir, you will have a court date for your preliminary hearing of January 27th at 8:30 a.m., and that's via Zoom. Now, you're going to have a second court date. That's going to be your bond hearing date, because I am going to no bond you this morning. And that second court date is going to be January 31st at 8:30 a.m., and that's going to be via Zoom. Now, as to your bond amount, sir, on that arson degree, you're on a no bond. The burglary, no bond. Financial transaction card theft, you have a bond of $10,000. Robbery by force, no bond. Kidnapping, no bond. Battery, you have a bond of $3,500. And the possession of drug-related objects, you have a bond of $500. Now, you do have special conditions if your bond is modified at a later date, sir. And they are to stay away from David Lightsey, as well as from the address of 6278 Sarah Boulevard. Again, that alleged victim, David Lightsey, and the address of 6278 Sarah Boulevard. Do you understand me, sir?
Sure.
All right, good luck to you, Mr. Kearns. All right, are you Mr. Dudley?
Yes, sir.
All
Yes,
right, so Mr. Dudley, you are charged with 1 count of aggravated assault as a felony and 1 count of simple assault as a misdemeanor. Now, because you are charged with a felony, sir, your next court date, should you not make your bond, will be your preliminary hearing, and that's going to be on January 27th, and that's at 8:30 a.m., and that's going to be via Zoom. Again, that's January 27th at 8:30 a.m. via Zoom. Your bond amount on the ag assault is $25,000. On the simple assault, $2,500, for a total bond of $27,500. You do have special conditions, sir, and they are to stay away from 2 people, Malik Patterson and Jatavia Leverock. Do you understand that?
Yes, sir.
Now, based on the information you provided to me this morning, sir, I am going to go ahead and I'm going to appoint you a court-appointed lawyer free of charge. So you will have a lawyer to assist you on your case. Good luck to you, Mr. Dudley.
Thank you.
Thank you. All right, should be Hammock, Kelly, and then Osei Kofi.
How you doing, Your Honor?
Good morning. Are you Mr. Hammock?
Yes.
Mr. Hammock, you are charged with 1 count of malice murder, 1 count of possession of a firearm during the commission of a crime, sir. You have 2 upcoming court dates. That first is going to be January 27th at 8:30 a.m. That second is going to be January 31st at 8:30 a.m. The one on the 27th, sir, is your preliminary hearing. The one on the 31st is going to be your bond hearing. Based on the charges, sir, that are before me, sir, I am going to no bond you on both charges. As I noted, I think I said already. I'm sorry.
Could you say that on 30th date, start from the 30th date again? It was glitching out.
Sure. The 27th is your preliminary hearing, Mr. Hammock, and the 31st is your bond hearing. And I have, based on the charges before me, I am going to no bond you this morning. Do you understand that?
Okay.
All right. Any questions of me, sir?
No, sir. I just wanted to let you know that I was standing my ground.
No, Mr. Hammock, Mr. Hammock. You don't want to put, no, sir, not on this recording. No, sir.
I know,
This is not,
you know.
Mr. Hammock, this isn't the place for that. Okay, speak to your lawyer about that.
Okay.
All right, good luck to you, sir. All right, Kelly, Osei, Kofi, and Simon. All right, are you Mr. Kelly?
Yes.
All right, so Mr. Kelly, you were charged with 1 count of possession of marijuana, 1 count of dangerous drugs, 1 count of expired tag. All is misdemeanors, sir. Now, because you were charged with misdemeanors, Mr. Kelly, you have a right to the preliminary hearing that we spoke of, or, sir, you can waive that right to that preliminary hearing. Would you like to have that hearing, sir, or waive that hearing?
Could you tell me what the meaning of the hearing was again?
Yes, sir. So a preliminary hearing, the purpose of that hearing, sir, is for you to determine whether or not, or not you, but the judge to determine if there's enough evidence against you for your case to move forward to the prosecutor. So it's not your trial. It's not where they will do guilt or innocence, but whether they'll determine if there's enough evidence. Now, you don't have to decide to have that preliminary hearing if you don't want to. If you don't want to have it, I can go ahead, skip it, and move your case on up to the prosecutor. It does move your case a little bit faster if you so choose. All right, so knowing that, sir, would you like to have that hearing or waive that hearing?
Waive.
All right, sir, so I am showing you are asking me to waive your preliminary hearing this morning, so the deputies will have a piece of paper for you to sign, Mr. Kelly. Now, as to your bond amount on the, I'm sorry. Give me 1 second, Mr. Kelly, give me 1 second. Yes. So I was reviewing the paperwork we have on you here, Mr. Kelly, this morning. I want to tell you, we're going to waive it. You're going to waive your preliminary hearing, and I am going to go ahead and release you this morning without a bond. And so your case is not over, Mr. Kelly. However, you will not have to pay a bond to get out. So you'll be released later today. Do you understand that?
Sir.
But I need you to understand, Mr. Kelly, that does not mean your case is over again. So when you leave today, please make sure that whatever address the sheriff's office has on file for you is the best known address for you, so that they can make sure that you get your next court date in the mail. Okay?
Okay, thank you.
All right. Good luck to you, Mr. Kelly. All right, give me 1 second, sir.
Go ahead back to the house and let it go.
And are you Mr. Sean?
Yes.
All right, so Mr. Sean, you are charged here with 1 count of criminal trespass as a misdemeanor. Now, because that is a misdemeanor, sir, you have that right to that preliminary hearing I spoke of earlier, or you can waive that right to that hearing. Would you like to have it or waive it, sir?
Waive it.
All right, so I am going to show that you are waiving your hearing. That means this morning the deputies will have a piece of paper for you to sign after we are done speaking. Now, as to your bond, sir, on the criminal trespass, your bond amount is $3,000, and you do have to stay away from the address of 9801 Herrick Drive. Again, that's 9801 Herrick Drive. So as I said earlier to other folks, if that is where you were living prior to this incident happened, please understand you cannot return to that address unless and until your case is closed, your bond is modified, or you make your bond and the sheriff's office has someone to escort you out there. Do you understand?
Yes.
All right, sir. Well, unless you have any questions for me, that's all I have for you, sir.
All right.
All right, good luck to you.
Okay, I got one question.
Yes, sir.
Okay, my bond 3,000. So can I pay it today to get out, or what?
You sure can. Yes, sir. As soon as we're done, if you just want to let the sheriff's office know, they should be able to have somebody get out there or assist you in that matter.
All right. Thank you very much.
Yes, sir. All right. The last 3 I've got on jots are Simon, Williams, and Wink. Are you Mr. Simon?
I am, sir.
All right. So, Mr. Simon, you were charged here with 1 count of battery family violence, sir. That is a misdemeanor. That means you have a right to that preliminary hearing that I mentioned earlier, or you can waive that right, sir. Would you like to have it or waive it?
I like to waive it.
All right, sir. So I am showing that you are waiving your right to that preliminary hearing. And so that means the deputies will have a piece of paper for you to sign here shortly. Now, as to your bond, sir, your bond amount is $4,500. You do have special conditions, and they are stay away from Madia Brahman and the address of 636 Briar Hill Court. Again, that's 636 Briar Hill Court, Madia Rahman. And so again, if that's somewhere you were staying before this alleged incident happened, you are not allowed to return unless your bond is modified, your case is closed, or if someone from the sheriff's office escorts you out there while once you bond out. Okay?
Right.
All right. Good luck to you, sir.
I thank you, sir.
Thank you.
Hey, send your hands out for sure. Y'all going back to the house. And you have questions, sir? Yeah. That one go up. All right. Yeah.
All right. Are you Mr. Williams?
Well, sir, she the only one that has anymore.
I'm sorry.
Yes, sir.
All right, so Mr. Williams, you are charged with 1 count of misdemeanor taking, 1 count of battery family violence. And so because those are misdemeanors, sir, you have a right to the preliminary hearing or waiving it. Do you want to have it or waive it, sir?
Waive it.
All right, sir. So I am going to show that you are waiving your right to that preliminary hearing. And so the deputies will have a piece of paper for you to sign this morning. Now, as it relates to your bond, sir, your bond amount is $3,500 on each count for a total of $7,000. You do have special conditions, and they are to stay away from Marissa Quinsney, as well as the address of 1048 Flat Shoals Road. Again, that's Marissa Quinsney and 1048 Flat Shoals Road. I am going to go ahead and appoint you a court-appointed lawyer free of charge. So you will have a lawyer to assist you in your case. Okay, Mr. Williams?
Yes, sir.
All right, any questions for me, sir?
No, sir.
All right, good luck to you, sir.
All right, thank you.
Thank you. And then lastly, Mr. Wink on Jots. All right, are you Mr. Wink?
Yes, sir.
Mr. Wink, you are charged with 1 count of felony false imprisonment and 1 count of misdemeanor battery, sir. Because you are charged with a felony, if you do not make your bond that I'm going to give you this morning, your next court date will be your preliminary hearing, and that will be January 27th at 8:30 a.m. via Zoom. Again, that's January 27th, and that's 8:30 a.m. via Zoom. Now, as to your bond amount on the misdemeanor battery is $3,500. On the felony false imprisonment, $7,500, for a total of $11,000. You do have special conditions, sir, and they are to stay away from the alleged victim, a Miss Cassandra Meredith. Do you understand that, sir?
Yes.
All right, sir. Do you have any questions about anything for me, sir?
No.
All right, sir. Then I believe that's all I have for you this morning, Mr. Wing.
I'm sorry, you did say 11,000, right?
Yes, sir. 11,000.
Okay.
Well, 11,000. Yep, you are good to go. And I believe you said you had no questions for me, sir?
No, none at all.
All right, sir. Good luck to you.
Okay.
Hey, the door open, go ahead.
All right.
Oh, you sound right.
All right, so going off Jots now with our man. I believe I have, are you Mr. English?
Oh, you want English first? Go ahead, English, come right here.
Who is this? Okay. That's just who I had, but who is that gentleman?
No, English right here now.
Okay. Are you Mr. English?
Yes, sir.
Mr. English, I'm showing here you are charged with 1 count of theft by shoplifting, sir. That is a misdemeanor. Now, because that is a misdemeanor, sir, you have a right to the preliminary hearing that I spoke of earlier, Mr. English, or you can waive that right to the preliminary hearing. Would you like to have that preliminary hearing, or would you like to waive it?
What do you think would be best? I mean,
He's not going.
you think waiving it would be?
Well, so here's the thing, sir. I'm not allowed to give you advice, legally speaking, and so you got to make that decision. But let me go over it with you again, so I can make sure you understand the difference. Okay. So a preliminary hearing, sir, again, that's the hearing where you are present, the judge is present, the police officer is present that arrested you, right? When all parties are present, they're going to go over the evidence against you and to determine if there's enough evidence for the case to go forward against you. If they say, yes, there is enough evidence, then your case is sent to the prosecutor. If they say, no, it's not enough evidence, your case is dismissed. But let me tell you, if they dismiss your case right there, it doesn't mean the case goes away. It just means for the time being, it's gone. And if the prosecutor decides they want to bring it back, they can, or they can choose not to. Or you can tell me, so you can say, Judge, set that hearing date. I want to see what happens. Now, the alternative is you can tell me, Judge, you know what? I don't want that hearing at all. I'd rather move my case along a little quicker. And then you'll waive that right, the hearing, and then the case will go ahead on up to the prosecutor for review. Knowing that, again, you have the right to waive the hearing. You have the right to have the hearing. Would you like to have that hearing or waive that hearing?
I guess have it.
Okay. Do you have any questions about anything that we just talked about and what it means, sir?
No, that's fine. I understand.
All right. All right. So
We'll have the hearing, I guess, 7 to 14 days, 7 to 10 days.
no, so it's going to be about 30 days out, Mr. English. So your hearing date for
You
I'm sorry,
said what?
it's going to be 30 days out.
Oh, no, he said, I had a guy up here at the front, when I came in, he said it'd be 7 to 14 days.
No, sir. No, sir. Mr. English. Mr. English. Mr. English.
No,
They don't determine the court
That's
date.
crazy, bro. That's crazy. 30 days in here, bro. 30 days.
Mr. English, if you don't make your Mr. English, If you don't make your bond, you'll have that hearing.
State bond, you just killed my.
All right. So have a good day, Mr. English.
Damn.
Have a good day.
You sit here like I'm trying to work
Next
the
minute, step up.
system or something.
All right. Let's see. Give me 1 second, deputy. So I've set his hearing date. It's going to be January 28th. Misdemeanor. We're going to give him a court-appointed lawyer. And
Cool. Whatever you got going on, I'm just judging.
now you, Mr. Garcia.
Huh?
What's your name, sir?
Travis McGee,
McGee.
Travis McGee.
Okay.
You got one on? St. Johnston.
Give me 1 second, Mr. McGee. All right, so Mr. McGee, you are charged with 1 count of criminal trespass, sir. That is a misdemeanor. Because you are charged with a misdemeanor, sir, you have a right to that preliminary hearing we spoke of, Mr. McGee, or you can waive that right to the hearing. Would you like to have your hearing date set or waive it, sir?
Of course, but I was trying to see if I could get a signature bond because I really didn't know what was going on. I was just.
Mr. McGee, I'm not Mr. McGee. Mr. McGee, you are not Mr. McGee. Mr. McGee, you're not gonna get a signature bond. I'm not allowed to discuss your case. Remember, I said earlier, this is being recorded. So I went ahead and set your preliminary hearing date, sir. Your preliminary hearing date is gonna be January 28th of 2025 at 8:30 a.m. via Zoom. Your bond amount's $5,000, Mr. McGee.
January what?
January 28th. So if you don't make your if you don't make your bond, you'll be there till the 28th for your prelim. Your bond amount is $5,000, sir, and you are to stay away from the Atlanta airport unless you are there for work or you are there for business. Excuse me, to travel. Thank you, Mr. McGee. Thank you, sir. Mr. McGee, thank you.
Okay, come on.
I thought you said 2 weeks though.
Mr. McGee,
Step away from the
thank you.
computer
Oh,
before we
okay.
take you away from the computer. Have a good day. Next.
All right, and what's your last name, sir?
Mills.
All right, Mr. Mills, you are charged with 1 count of criminal trespass, sir. That is a misdemeanor. Because it's a misdemeanor, Mr. Mills, you have a right to a preliminary hearing, sir, or you can waive that preliminary hearing. Would you like to have that hearing, sir, or waive it? All right, so Mr. Mills, I'm gonna go ahead and set that hearing date for you. It's gonna be January 28th. So if you don't make the bond, I'm gonna give you your next court date will be January 28th at 8:30 a.m. via Zoom. Do you understand, sir?
Yes.
All right, so as to your bond, sir, your bond amount is gonna be $2,500. You do have special conditions, sir, and they are to stay away from the Atlanta airport unless you are there for work or travel. All right, Mr. Mills, good luck to you, sir. All right, what's your last name, sir?
Riley, R-I-L-Y.
All right, so Mr. Riley, you are charged with 1 count of simple assault, sir. That is a misdemeanor. Because it is a misdemeanor, you have a right to a preliminary hearing, sir, or you could waive that right to that hearing. Would you like to have the hearing or waive it?
Well, I'm gonna say waive it, but this is why, because I literally got locked up for this last year. And
Mr. Riley, I cannot discuss with you the facts of your case.
okay, I was just letting you know, like this.
Mr. Riley, I cannot discuss with you the facts. All right, so I'm gonna go show that you are asking me to waive your hearing. So once we are done speaking, the deputies will have a piece of paper for you to sign. All right, now I have gone ahead and appointed you a court-appointed lawyer. So Mr. Riley, you will have a lawyer free of charge to assist you on your case. Now, having shown that you waived it, your bond amount, sir, on the simple assault charge is $5,000. Do you understand that?
Yeah.
All right, good luck to you, sir.
All right. I'll go ahead and sign the waiver that you just.
All right, are you Mr. Tucker?
Yes.
All right, so Mr. Tucker, you are charged here with 1 count of arson in the 1st degree. That is a misdemeanor, sir. Are you currently working? Or excuse me, that is a felony. Are you currently working, Mr. Tucker?
No. No, sir.
You said no?
No, sir.
Okay. Now, your bond amount, a couple of things I need to tell you, Mr. Tucker. Because this is a felony, sir, you will have, I'm gonna give you a bond this morning, but if you don't make that bond, you're gonna have you're automatically given a preliminary hearing date. So your bond amount is $15,000. You are going to get a court-appointed lawyer here this morning. The preliminary hearing date is going to be January 27th, yeah, at 8:30 a.m. And that's going to be via Zoom. Again, that's January 27th, that's 8:30 a.m. and that's via Zoom. So again, you're charged with a felony, sir. Your prelim date is January 27th at 8:30. I did give you a court-appointed lawyer here free of charge, as well as your bond amount is $15,000. Do you understand, sir?
Yes, sir.
All right. Any questions I can answer for you, Mr. Tucker?
No, sir.
All right, Mr. Tucker, good luck to you.
20 years.
But, sir, step up.
All right, give me 1 second here. Give me 1 second. Okay, and what is your last name, sir?
Kelly Gregory.
All right, so Mr. Kelly, you were charged with 1 count of burglary as a felony, sir, and 1 count of criminal damage to property in the 2nd degree, which is also a felony. Do you understand that, sir? Sir? Mr. Kelly, can you hear me?
Yes, sir.
Okay, so you hear what I said? You're charged with 2 felonies, okay?
Mhm.
Now, because you are charged with felonies, sir, what that means is I'm going to give you a bond hearing this morning. If you do not make that bond that I'm going to give you this morning, then you're going to get an automatic preliminary hearing date. Your preliminary hearing date is going to be January 27th at 8:30 a.m., and that's going to be via Zoom. Again, that's January 27th. That's going to be at 8:30 a.m., and that's going to be via Zoom. Do you understand that, Mr. Kelly?
Yes, sir.
Now, Mr. Kelly, based on the information that you provided to me this morning, I am going to go ahead and appoint you a court-appointed lawyer this morning. So you will have a lawyer free of charge to assist you on your case. Do you understand that?
Yes, sir.
Now, I have gone ahead and reviewed the information here that you provided and that I reviewed on the arrest warrant against you. So as to your bond amount, sir, your bond on the burglary is a no bond. The bond on the criminal damage is also a no bond. And the reason being, sir, is you are currently on probation from what I can tell out of Muskogee County. And so in addition to that preliminary hearing date on the 27th, you will also have a bond hearing date on January 31st that will also be at 8:30 a.m. and that will also be via Zoom. Do you understand that, sir? Mr. Kelly?
Yes, sir.
All right, sir. Do you have any questions of me?
No, sir.
All right, good luck to you, sir.
What's your last name?
Umachi.
Hang tight for a second. Sit back down.
All right, is there a Garcia deputies or did he make bond?
No, he's here. Let me switch you around.
Okay.
That's it.
All right, Mr. Garcia, can you hear me? Okay. All right, so Mr. Garcia, you were charged with several accounts here. You were charged with 1 count of theft by shoplifting, 1 count of giving false name, 1 count of obstruction, and 1 count also of giving a false date of birth and felony criminal damage. Now, because you are charged with at least one felony, sir, I'm going to give you a bond this morning. But if you don't make your bond, your next court date is going to be January 27th at 8:30 a.m. via Zoom. Again, that will be January 27th, and that's going to be 8:30 a.m., and that's going to be via Zoom. Now, as to your bond, the theft by shoplifting, sir, I have dismissed that count. The giving false name, I have given you a bond, excuse me. Give me 1 second, I'm sorry. Let me check something here. I need to correct that. Okay. Yes, sir. So as to the theft by shoplifting, I have dismissed that bond, sir. As to the false name, I have dismissed that bond. You do have a remaining theft by shoplifting as a felony. That bond amount is $5,000. You do have a remaining false name, sir. That bond amount is $1,500. The obstruction, $2,500, and you also have a bond amount on the felony criminal damage of $3,000. So your total bond, sir, is $12,000. You do have a special condition, Mr. Garcia, and that is to stay away from 6065 Jonesboro Road. Again, that is 6065 Jonesboro Road. Do you understand that, Mr. Garcia? All right. I have gone ahead, Mr. Garcia, and I'm going to appoint you a court-appointed lawyer. So he will have a lawyer free of charge to assist you on your case, sir. Good luck to you. Thank you, Mr. Garcia. And so that should leave just our fugitive.
Yes, sir.
Okay. And is it Mr. Umachi? Is that correct, sir?
Yes, sir. Can you see me?
Yes, sir. I can see you. Yes, sir. All right. So, Mr. Umachi, I need you to understand. So your situation's a little different.
I know.
You have a warrant not here out of Clayton County or specifically the state of Georgia, but out of Aiken, South Carolina.
Yes.
It alleges in the warrant that you were charged with burglary in the first degree and grand larceny.
Yes.
So here's where we are with yours. You got a couple options. Option 1 would be you tell me, Judge, I'm going to fight this charge when I get back to Aiken, South Carolina. So I need you to go ahead and send me back.
Yeah.
Okay.
Yeah.
Option 2 would be, Judge, I don't believe that Aiken police officers did the procedure, not the charge, but the procedure right in order to take this warrant out for me. And if you believe that they did it incorrectly or you want to fight it, you have a right to. But what that means is, hold on. What that means, if you want to fight the procedure, you got to give them 60 days to set a hearing date for you. Here, so that means you'll wait in the county jail for 60 days. If after that 60 days, they don't pick you up, they don't have the hearing date for you, then they get another additional 30 days. So a total of 90 days to try to set that hearing date for you here in Clayton County with the Aiken attorneys and police officers.
Yeah.
So again, you have the right to say, Judge, go ahead and send me back. I'm going to fight the charge when I get there. Or Judge, I don't think they did the procedure correctly. And in which case, if you believe they did it incorrectly, we'll set a hearing date for you as soon as possible in the next 90 days while you await the Aiken officers to come down.
No.
Now, lastly, if for some reason you tell me, Judge, go ahead and send me back, and they don't come get you in those 30 days, the jail will release you, and then you're free to go. So knowing that, sir, how would you like to proceed? Would you like to skip the hearing date or go ahead and have me set it?
No. I want to waive the what's called like I want to go to South Carolina.
Okay.
This whole thing, I don't even understand what happened.
No. You don't want to. Don't talk about it.
Understand? Yeah, I want to go back to South Carolina.
All right, sir. So that means there's going to be about 6 copies of a piece of paper. The deputies are going to have you sign. Once you sign that piece of paper, sir, you'll be on your way.
All right. I got a question. You said it's up to 30 days. How fast can they come? If I have somebody on the outside contact them.
That's on them. I really can't tell you that how quickly it's going to be.
So
that again?
With this right here, just real quick, because I was about to start signing. I gotta sign all 6 of them, or just one I'm gonna do?
Yes, sir. You got to sign all 6.
Okay, all right, cool. But what were you saying?
No, I was just going to say, you were asking me how quickly, and I was going to say, I can't tell you that. It's just really up to them.
Okay,
All right, sir. Good luck to you.
yes.
All right. All right, deputies, I believe that's everybody. Is that correct?